Hello everyone, my name is Anthony Simiyu, and joining me on set is
Ruth Tanui
and Allan Ong'ato.
All of us are advocates of the High Court of Kenya. We've been running a series under the name Legally Correct, which covers a number of issues, which are legal issues. Of late, we've been running a series on matters elections, and today we'll be sharing with you what to do when rigged out of a nomination exercise. First thing that happens when you've just been rigged from a nomination exercise, you feel disgruntled that something has been done. Your political party has given the political seat to someone else. The party ticket has been given to someone else other than you. The first point you need to consider going before you even rush to the courts is to move the internal dispute resolution mechanism under the party. The law requires that you need to approach your party outlining your complaint. You need to understand, number one, is it just a matter of the party that has wronged you, or is it that your competitor did something that made the election to be a shamble, the nomination process? And here we are giving consideration to nominations that have happened after an election. You need to have a complaint. The complaint could take whichever format, but a formal complaint needs to be lodged with the political party. The political party will then have 30 days within which to try and address your concerns. If at all they don't address your concerns, then you're at liberty to move elsewhere, but you need to exhaust that. Most important to the parties, once a complaint has been lodged, the political parties need to investigate the complaint and give you a fair chance to give out your case in terms of what you consider having done or having not done that led to you being rigged out of a nomination exercise. Of key consideration, the party needs to afford all parties, the person who's complaining and the person who's not complaining, a fair chance to explain out their case, and eventually a decision will be made. That decision will form the basis of whatever proceedings that will take from there. But of importance first, you don't rush to court. You need to exhaust all mechanisms under the party. Political parties are required under law to have election boards who will be responsible for handling nomination disputes should they arise. These boards are normally constituted by political parties and its membership. There are certain rules that have been recommended by the Political Parties Disputes Tribunal to guide the processes. So it's something that political parties would want to consider. That's the model rules that are recommended by the Political Parties Disputes Tribunal.
I'm going to talk about the political parties dispute tribunals. So if my friend here, Simiyu, has talked about IDRMs. So if you have taken your dispute to IDRM and you're not satisfied, that's where the PPDT...
IDRM what is IDRM in full? Internal dispute resolution mechanism.
Yeah. So if you're not satisfied, you bring the dispute now to the Political Parties Dispute Tribunal. I'll be referring to it as the PPDT. So the PPDT is established under the Political Parties Act, which has stipulated the role that it plays. So the jurisdiction of the PPDT, it has two jurisdictions. The first jurisdiction now is for matters arising from the IDRMs concerning party primaries.
On appeal.
Yes,
isn't it?
Yeah, matters arising from on appeal.
Okay.
It has jurisdiction over matters arising from IDRMs concerning party primaries, or disputes between party members and political parties, or disputes between members themselves, or political party, or disputes between coalition partners. And it also has the PPDT also has direct jurisdiction. There are some matters you don't have to take them through the IDRM. So matters like disputes between an independent candidate and a political party, or any appeals from decisions of the Register of Political Parties, and disputes arising out of party primaries.
Of course, we are all aware of the controversial Political Parties Amendments Act, the ones that were passed recently in very controversial circumstances. And the amendments have clarified the role of the courts on appeal from decisions of the political parties disputes tribunal, which obviously come from the internal dispute resolution mechanisms where the political disputes tribunal is exercising its appeal jurisdiction. Initially, it was not clear because the Political Parties Act was saying a decision by the High Court would be final, whereas the rules, whereas the subsidiary legislation under the Political Parties Act was saying that an appeal could go all the way to the Supreme Court. So the amendment has clarified that an appeal can only go up to the Court of Appeal. The decision of the Court of Appeal is final. Now, probably an additional issue, the Independent Electoral and Boundaries Commission has also been given jurisdiction under the law to adjudicate upon some disputes emanating that could arise during the election process. This mandate sort of overlapped with that given to the Political Parties Disputes Tribunal. To resolve this issue, the Political Parties Disputes Tribunal and the Independent Electoral and Boundaries Commission have come up with a memorandum of understanding that has sort of demarcated their separate jurisdictions, so that the IEBC now only adjudicates upon disputes relating to qualifications of candidates. So if a candidate is disqualified on the basis that they do not qualify, probably academically or...
I think that could be a good point,
Yeah.
Considering whatever happened in Wajir in 2017. We had a governor who had been elected, and one of the candidates who was dissatisfied with the results raised the issue that the sitting governor did not have a degree, and it's a requirement that you're meant to have a degree. How is a court now to consider matters of qualifications at the petition level? So perhaps
Yes.
it's time the tribunal, the IBC tribunal, looked into such matters.
Yes.
For parties to ensure that candidates who they front to be their flag bearers are qualified.
And just to add on that, people who follow this kind of things closely will remember that this was a very contentious decision because the Supreme Court overturned the decision of the Court of Appeal and reinstated the governor for Wajir, even though there were question marks as to his qualifications, his educational qualifications. And the reason is, at that level, the argument, the IEBC tribunal was already out of the picture by the time the dispute had been lodged with the courts. Therefore, these are jurisdictions that ought to have been exercised by the IEBC tribunal, and the courts could not exercise their original jurisdiction to adjudicate upon that issue. Of course, the opinion is divided. I'm sure Simiyu here disagrees.
I vehemently, again, but the Supreme Court being the highest court in the land, its decision is final and binding on all courts other than itself. So we hope that at some point the Supreme Court will reconsider its decision, because it would be absurd if at all we had a sitting leader who does not possess qualifications, but because we are past the stage we could challenge their qualifications, then we are led by someone who does not hold the constitutional qualifications.
Well, the counter argument to that would be there could be many ways of removing him from that position, including the criminal process. So you cannot force the Supreme Court to usurp the mandate of an independent body, quasi-judicial body, which mandate has been donated to it under the law on the pretext that a governor who does not qualify cannot be seen sitting on the chair, continuing to serve as governor. There are many ways that could be pursued, and for that anomaly to be corrected. That would be a counter argument.
Interesting.
Yeah, but the jury is out there.
The Supreme Court is last, the final.
Yeah.
Thank you for watching. If you have any questions, feel free to leave them at the comment section. And if there's any topic you'd want us to talk about, please feel free to also suggest at the comment section.
You can connect with us on social media, either via Facebook or Twitter or LinkedIn or Instagram. The handles are right here below the screen. I would really love to hear from you.
We also have a free consultation form on our website, www.legallycorrect. You can feel free to fill it. Also, you could email us at hello@legallycorrect.com, and we'd like to hear from you. Until
Thank
next
you very
time.
much. Until next time.
Kwaheri.
Bye.
Ciao.